So there's some pretty big news coming out of Guwahati, Assam, around June 7th, just recently in 2025.
Oh, yeah. What's been happening there?
Well, the Assam government, they've decided to pull out a really old law. I mean, really old.
How old are we talking?
We're talking about the Immigrants Expulsion from Assam Act. It dates all the way back to 1950.
1950. Wow, that's practically ancient in legislative terms. Why on earth dust that off now?
Well, the stated reason is pretty direct. They want to use this 75-year-old law to tackle illegal immigration more quickly
Faster. Okay.
by
Okay.
using something they're calling pushback orders. And the key thing here is it seems designed to bypass the usual, often quite slow processes, like the foreigners' tribunals.
Okay. So efficiency is the name of the game.
Hmm.
Speeding things up by avoiding the established legal routes.
Seems like it.
That immediately makes you wonder, though, about how that actually works on the ground. Well, who gets caught up in it?
Exactly. And the announcement, the big push, came from Assam's chief minister, Himanta Biswa Sarma. He actually pointed to something fairly recent to back this up.
Oh, what was that?
He mentioned a Supreme Court hearing from back in October 2024. It was about Section 6A of the Citizenship Act. And he seems to feel that the court, during that hearing, essentially gave a nod to the power, the validity of this old 1950 law.
Interesting. So he's framing it not just as an administrative decision, but one with sort of a recent judicial, well, not blessing exactly, but maybe validation.
That seems to be the interpretation. Yes, it's a significant claim to make.
Definitely.
So for you listening, this is a really complex situation. It's got deep historical roots, legal twists, political angles. So today we're going to take a deep dive. We'll unpack what this 1950 Act actually is, why it's suddenly front and center in 2025, what pushback really means for people who it affects, and just the bigger picture consequences.
Yeah, sounds like a real tangle of history, law, and crucially human lives. It's a high-stakes move for sure.
Absolutely. Okay, let's maybe start by rewinding back to 1950.
Setting the scene.
Right. India's a very new republic, just finding its feet. The trauma of partition is still fresh, and there's significant migration happening, especially from what was then East Bengal, now Bangladesh, into Assam. This was a major concern back then.
Understandable. That post-partition era saw huge population movements, massive upheaval, particularly in border states like Assam. Lots of anxiety.
Totally. And this 1950 Act was created specifically as a tool for the authorities to manage that situation. The idea was to give them the power to identify and, well, deport anyone whose presence was seen as detrimental to the interests of the general public of India or any section thereof.
That phrasing, detrimental to the interests of the general public, that sounds incredibly broad.
It is, isn't it? Very open-ended. It even specifically mentioned protecting scheduled tribes, which tells you it was framed around managing these large-scale demographic shifts and their perceived impact.
So built for an era of mass migration concerns, designed as a pretty powerful, maybe even blunt instrument.
And here's the crucial part, the thing that probably makes it attractive now. Unlike the Foreigners Act or the Foreigners Tribunal system that developed later, this 1950 law, well, it doesn't explicitly require a judge or tribunal to sign off before someone can be ordered removed.
I see.
It looks like it was set up for a much faster, more administrative kind of expulsion process.
Okay, so its original design seems to skip the very judicial review steps that are now seen as slowing down the current immigration system. That connects the dots to 2025, right?
Exactly. Let's jump back to the present day. Why now? Why revive this specific law in 2025? Well, it plugs right into Assam's long, really complex history with immigration.
A history that's shaped so much of the state's politics and society.
Definitely. You've got that long 262-kilometer border with Bangladesh, which has always been, let's say, porous.
Yeah, managing a border like that is a constant challenge anywhere in the world.
It is. And this history fueled decades of agitation, social movements, political turmoil in Assam, which eventually led to the Assam Accord in 1985.
Right, the Accord.
And a really key part of that accord was setting a clear cutoff date for citizenship, March 24th, 1971. The idea was anyone who came into Assam after that date would be identified as an illegal immigrant.
That date became the bedrock for everything that followed, didn't it? For identifying who belonged and who, legally speaking, didn't.
It did. And the big exercise meant to implement this, the National Register of Citizens, the NRC. Well, that was supposed to be the definitive answer. Create a list of genuine citizens.
But it turned out to be incredibly messy.
Hugely messy, an enormous complex process. The final draft came out in 2019, and it excluded about 19 lakh people, that's 1.9 million. But the whole thing was just incredibly slow, full of glitches, appeals, challenges. It's left a huge number of people kind of in limbo, still fighting to prove they belong.
Yeah, the scale was massive, and the process just got bogged down. It didn't really resolve things for many people.
And then you have the foreigners' tribunals, the system that was meant to be the legal route for deciding if someone excluded from the NRC or otherwise suspected actually is a foreigner.
Right, the judicial check.
But that system has faced a barrage of criticism, too. People say it's slow, the rulings are inconsistent, there are procedural issues. It essentially created another massive bottleneck.
So you've got the NRC leaving people in limbo and the tribunals struggling to process cases effectively, a recipe for frustration.
Exactly. And that's the context for Chief Minister Sarma reviving the 1950 Act. He's basically saying, look, the current systems, NRC, tribunals, they're too slow, too inefficient.
So this is the alternative.
He's been very clear about it. There's a quote attributed to him saying something like, this time, if someone is identified as a foreigner, we won't send them to a tribunal. We'll just keep pushing them back.
Wow.
Right?
Blunt. It cuts right to the chase, bypassing the tribunals altogether for direct action.
Pretty much. And again, he connects this back to that Supreme Court mention in October 2024. He seems to be interpreting that as a justification, saying the highest court recognized this 1950 law as a valid tool the state can use.
So the argument is the court acknowledged this tool exists, so we're going to use it to cut through the delays.
That appears to be the rationale presented. Okay, let's really get into this pushback idea. What does it actually mean, and what are the legal red flags people are raising?
Yeah, because pushback sounds quite clinical, almost like a euphemism.
It does, and essentially it seems to mean deportation, but crucially, without going through those layers of legal process, the judicial oversight that other immigration laws usually require, the information suggests district commissioners, local administrators can issue these expulsion orders.
Right. So taking the decision away from a specialized tribunal or court and giving it to an administrative official, that's a fundamental shift in who decides and based on what standard.
It really is. And that's where the big legal worries come in. Remember the language in the 1950 law, detrimental to the interests of the general public.
Still sounds incredibly vague.
Exactly. How do you define that consistently? Who gets to decide what's detrimental? It leaves a lot of room for interpretation, potentially arbitrary interpretation.
And that's always the danger with broad legal language, isn't it? It can be applied inconsistently, maybe even unfairly, depending on who's doing the applying.
Precisely. And the main fear critics' voice is this. Without a judge or tribunal looking at the evidence, hearing the person's side, ensuring procedures were followed for each individual case, well, the risk of mistakes, of arbitrary decisions, of this power being misused goes way up. Especially, they worry, against already marginalized communities.
Due process exists for a reason, right? To prevent exactly that kind of arbitrary action, to ensure fairness, even if it takes time. Bypassing it feels inherently risky.
It does. Now, to be fair, the Supreme Court did find that the 1950 law itself can technically coexist alongside Section 6A, which deals with citizenship for those who came before 1971.
Okay, so the law itself isn't necessarily invalid just because Section 6A exists.
Right. And this is the point critics emphasize, just because the law exists doesn't automatically mean that this method of administrative pushback without individual judicial review fully respects fundamental rights. We're talking Article 14, equality before the law, and Article 21, the right to life and personal liberty.
That's a crucial distinction. The court might have said the statute is valid in relation to Section 6A, but that doesn't necessarily mean they signed off on this specific way of enforcing it, the administrative pushback, as being constitutionally sound in every instance, especially regarding individual rights.
Exactly. That seems to be the core legal battleground now. And to really understand the gravity, we need to look beyond the law books at the human cost.
Because these aren't abstract legal arguments for the people involved.
Not at all. These policies are directly impacting lives, often in devastating ways. There are some specific stories that really bring home what pushback can mean.
Yeah, those individual accounts are always powerful.
Take the case of Manawara Begum. She was declared a foreigner by a tribunal back in 2015. Apparently, she had documentation, like a certificate from her village head, supporting her claim. She appealed this decision, and her case was actually pending before the Supreme Court.
Okay, pending at the highest court.
Yes. Yet, she was detained in 2016, and then, in May 2025, she was reportedly pushed back across the border to Bangladesh.
While her appeal was still with the Supreme Court, that seems like a major disconnect between the legal track and the administrative action.
It certainly raises questions, and to make it even more distressing, her family apparently wasn't told what was happening. They didn't know where she was being taken. Imagine the agony, the fear for them.
That's terrible. A total lack of transparency, leaving the family completely in the dark. That's frightening.
It is. Then there's another story, Karul Islam. He was a retired school teacher. He and his siblings were declared foreigners by a tribunal in 2016. He fought it, appealed to the High Court, lost there, and was detained in 2018.
So he went through the system.
He did. But then in 2020, he was actually released based on a Supreme Court order regarding people detained for long periods. But then May 2025, he gets picked up again. And reportedly, he was taken to the border and left in no man's land between India and Bangladesh.
What? Just left there?
Apparently, it seems it was only after a public outcry that he was brought back.
Sent into a kind of stateless limbo? After years in the legal system and even a Supreme Court release order. These examples really highlight the potential for chaos, for lives being completely disrupted without a clear, fair process.
They really do. They show the sharp end of this policy. Lives turned upside down, potentially without full due process, families uninformed, people facing the terror of being stranded, and the underlying fear that even genuine Indian citizens, especially from vulnerable groups, might get mistakenly swept up in this.
It brings to mind the comparison mentioned in the source material, like being kicked out of your own house, the only home, without proper procedure.
That really hits home, doesn't it? Now, obviously, this policy hasn't gone unnoticed or unchallenged within Assam and India. There's significant pushback against the pushback, if you will.
Right. Political opposition, civil society groups.
Exactly. The All India United Democratic Front, or AIUDF, they're a major opposition party in Assam, drawing a lot of support from the Muslim community. They're alleging that this is basically harassment, that Indian Muslims are being targeted under this policy without proper evidence or verification.
So they see it as discriminatory action disguised as immigration control.
That's their contention. And then you have legal experts, human rights groups, student unions like the All BTC Minority Students Union. They're raising fundamental constitutional red flags.
Focusing on Articles 14 and 21.
Precisely, arguing that this administrative deportation, skipping the judicial review, violates the right to equality and the right to life and personal liberty. They've already started filing legal challenges directed initially to the Guwahati High Court, it seems.
So the legal fight over the way this law is being used is definitely heating up. It's not just about whether the 1950 law exists, but whether this application is constitutional.
Correct. And you really can't separate this from the wider political context, can you?
No. These things rarely happen in a vacuum.
Critics are pointing fingers directly at the ruling BJP and its broader political narrative, its Hindutva ideology. They argue this aggressive push on immigration, framing undocumented migrants primarily as a threat, is partly about mobilizing their political base, especially perhaps with state elections in Assam and potentially Bihar not too far off.
Using immigration as a political tool, a wedge issue, is a common tactic, unfortunately.
And critics often bring up that comment by Union Home Minister Amit Shah back in 2018, referring to undocumented Bangladeshi immigrants as termites. They see that kind of language as part of a deliberate effort to dehumanize and frame the issue in a particular way.
Yeah, language like that definitely shapes the public discourse and can make certain communities feel very vulnerable.
But then you have the counter-argument. Supporters of the government's action, they frame it very differently.
What's their perspective?
They emphasize Assam's unique situation, the genuine anxieties among indigenous communities about demographic change, about potentially becoming minorities in their own homeland. These fears are deep-seated, going back decades, and were a major driver behind the Assam Accord.
The accord which promised to protect their identity.
Exactly. So from this viewpoint, reviving the 1950 law isn't about targeting anyone unfairly. It's seen as a necessary, pragmatic step to finally enforce that 1971 cutoff date, to protect Assamese identity and resources, especially since the NRC and tribunals seem to have failed to do so effectively.
So they see it as a legitimate tool to address a long-standing problem, using a mechanism that bypasses the perceived inefficiencies of the current system.
That's the core of their argument. But beyond the internal politics and legal debates, there's a huge practical problem. Bangladesh.
Right, the receiving country. You can't just push people across a border if the other side won't take them.
Precisely. And Bangladesh has historically been quite firm. They generally don't accept deportees unless India provides solid proof that the person is actually a Bangladeshi citizen. Verification is key.
Which is difficult to do quickly, especially if you're bypassing the tribunals that were supposed to make those determinations.
Exactly. There have been some instances of cooperation, like in 2019, about 30 people were deported with help from the Bangladeshi Assistant High Commissioner in Guwahati, but that's a tiny number.
30 people. Compared to the 1.9 million excluded from the NRC, even if only a fraction are ultimately deemed foreigners, you're talking potentially vast numbers.
Vast numbers. Trying to push back thousands without that clear verification process and bilateral agreement, it's a huge diplomatic challenge. It could seriously strain relations with Bangladesh.
Yeah, you need a functioning system for verification and acceptance, and it doesn't sound like one exists for this kind of scale.
And there's another really vulnerable group we need to mention, the Rohingya people. Some are held in detention facilities in Assam, like the Matia transit camp, which is reportedly the largest in the country.
Stateless people fleeing persecution.
Exactly. Pushing them towards Bangladesh isn't a solution either. Bangladesh is already hosting hundreds of thousands, and sending them back could put them at immense risk, potentially forcing them into the conflict zones in Myanmar's Rakhine state.
That raises serious humanitarian concerns. Deporting them could violate principles of non-refoulement, not sending people back to danger.
Absolutely. Okay, let's talk numbers for a second, just to get a sense of scale. Figuring out the exact number of illegal immigrants is notoriously hard.
Yeah, definitions and data are always contested.
We have the 19 lakh excluded from the NRC, but again, that's not a final count of foreigners. Appeals are ongoing. And look at the actual deportation numbers from Assam before this recent push. Since 2013, using the old processes, only 166 people were deported in total.
166 in over a decade.
Yes. And of those, 147 went to Bangladesh. It just shows how gridlocked the previous system was at actually carrying out deportations.
That number really underscores why the government might feel the need for a drastic change if deportation is the goal. The old way clearly wasn't achieving it on any significant scale.
Right. But compare that to the recent reports. In May 2025, the Union Home Ministry apparently gave states a 30-day deadline to verify suspected immigrants. We're seeing action elsewhere, Gujarat, Rajasthan detaining thousands. And in Assam, this Operation Sindoor, as it's reportedly called, estimates suggest over 2,000 people have been pushed back just since May 7th, 2025.
Wow. Over 2,000 in less than a month compared to 166 over 10 years. That is a staggering acceleration. It shows this revival isn't just symbolic, it's leading to immediate large-scale action.
It certainly looks that way. And reports suggest the government is gearing up for more, trying to speed up detection, setting up more detention centers. But those core concerns aren't going anywhere.
The lack of transparency, families left in the dark, the potential for error and abuse without proper judicial checks.
Exactly. Those fears remain very real. And the Supreme Court's position is still kind of ambiguous, or at least open to interpretation. They upheld the validity of the 1950 law, sure, but they also apparently stressed the need for ongoing monitoring to ensure fair application of immigration laws.
Right.
Their specific order back in February 2025 was apparently about deporting 63 verified foreigners. The worry is whether Assam's current pushback operation is taking that specific order as a green light for much broader administrative removals without that same level of verification or due process for everyone being pushed back.
So the legal challenges will likely continue, focusing now on how the law is being implemented on the ground, arguing about whether it meets constitutional standards in practice.
That seems almost inevitable. So wrapping this all up, this revival of a 75-year-old law in Assam is clearly a major development. It's a gamble, really, an attempt to gain efficiency and enforce a long-standing political goal regarding immigration.
But at the potential cost of fairness, transparency, and individual rights. It starkly pits the state's perceived interests against fundamental legal principles.
It really does. And it forces us to confront that tension. How does a state manage complex issues like migration, historical anxieties, demographic change, while still upholding justice and human rights?
It's a dilemma faced in many parts of the world, but it feels particularly acute in Assam given its history.
And ultimately, behind the legal jargon and the political maneuvering, these are real people, real families, real lives being profoundly affected. It's about identity, belonging, and fear. It touches the very fabric of the state.
That point about the law being older than most citizens really sticks with you. It was designed for a different time, under different circumstances. Using it now, especially in this expedited way, requires incredible caution. It shouldn't be a blunt instrument.
The powerful thought to end on. It leaves us, and you listening, with a tough question. How do we navigate this complex terrain where history, identity, law, and basic human rights collide? What are the long-term consequences for individuals, for the state, for the country, when the drive for administrative efficiency potentially overrides the safeguards of due process and human dignity? That's something worth pondering long after this deep dive ends.